So I thought I might make a video in regards to statutory interpretation and kind of give some philosophical thoughts from a U.S. perspective. I usually look at these things online at various legal search engines because it's absolutely fascinating to me. But you might actually find it interesting looking through some of these things on online. Statutory interpretation is the process by which courts interpret and apply legislation. That makes sense. It can also go to regulatory interpretation. Okay, yeah, delegate in common law jurisdictions, the judiciary may apply the rules of statutory interpretation to both legislation enacted by the legislature and delegated legislation, such as administrative regulations. Well, let's look at what a regulation is. I'll try to pick out things. A regulation is an abstract concept of management of complex systems according to a set of rules. Yeah. So in government, typically regulation means stipulations of the delegated legislation drafted by subject matter experts. So like you delegate to the IRS to do tax things in the Treasury and things like that. And that makes sense. Or you delegate to the EPA for environmental protection because they're the experts on that. EPA, founded by, I guess, Nixon administration in 1970. They're experts on these things. Things of that nature. Right. So you have various canons of doing things. Also known as canons of constructions, canons can give common sense guidance in courts interpreting the meaning of statutes. Right. So most canons emerge from common law countries through the choices of judges. You often have the textual, which can go like plain meaning. This has come up in a number of U.S. states and countries. And then you have the rule against surplusage, where reading a statute would make it one or more parts of the statutes redundant, and another reading would avoid the redundancy, the preferred reading. Justum generis of the same class or nature. Expressio unius exclusio altruis, expression of one. Items not listed are impliedly assumed not to be covered by the statute or contract or term. See, you can apply this. So it's almost like grammatical rules of construction. You can have substantive rules, interpretation, certain values of promissory, policy values. National statute must be construed so as not to conflict with international law. That's, wow, from an 1804 case. It has also been observed that an act of Congress ought never to be construed to violate the laws of nations if other possibility of construction remains. I believe I've read criticism of this, that sometimes it's hard to identify what the law of nations are, and also this was a different conception of what laws of nations were in 1804. But in the U.S. Constitution, we have U.S. thing, we have the determination of ambulatory interpretation that a statutory construction can surpass other, or that statute passed, we have the last in time rule, which is actually worth looking into. For nearly 150 years, courts have applied the last in time rule to resolve conflicts between treaties and federal statutes, giving effect to whichever was enacted later. So what's 2019 minus 150? 1869, fair enough. Yeah, and you have all these, and they all criticize each other. These are the most common, I would say. Justum generis of the same kind or class. Expressio unius est exclusio alterius. The expression of one meant that one thing excludes others. I think that makes sense. And notice our sources award is known by its company. This one is actually slightly less known, I'd say. In paria materia, upon the same subject matter, common technical legal definition, and that would make sense. You want to use when a statute is ambiguous, its meaning may be determined in the light of statute's subject. All right. I think generally the process is that no matter where you are on the political spectrum, you try to figure it out from the textual perspective, but if you can't figure it out there, then you have to go to the substantive perspective. Sometimes you have to go to the legislative history. With regulations, you go to the Chevron doctrine, and then that you delegate. So if there's an ambiguous rule in a statute, then you go to the Chevron statute. Europe is developing its own rules. Actually, super interesting stuff on this. And I think that's actually incredibly important and vitally interesting to people. You have general theory, other theories. So you have like constitutional interpretation, plain meaning, mischief rule, golden rule. So like the plain meaning rule is also known as the literal rule. Is one of the three rules of statutory construction traditionally applied by English courts. The others are mischief rule and golden rule. The plain meaning rule dictates that statutes are to be interpreted using the ordinary meaning of the language of the statute. In other words, a statute is to be read for the is to be read for a word that is to be interpreted according to the ordinary meaning of the language, unless the statute explicitly defines some of its terms. Otherwise, unless there are results, would be cruel, absurd. Interesting. Mischief rule. One of the three. The main aim is to determine the mischief and defect in the statute in question has set out to remedy, and what ruling would suppress the mischief, advance remedy. In applying the mischief rule, the court may essentially ask, what part of the law what part of the law did the law not cover, but was meant to be recited by Parliament in passing the bills? Set out in Hayden's case, 16th century Exchequer's Court. Interesting. Golden rule, one of the 30 rules. The rule can be used to avoid the consequences of literal interpretation that manifests in absurdity or obnoxiousness. Fascinating. The rule can be applied two different ways, namely named respectively the narrow approach and the wider approach. A lot of this, specifically the golden rule, comes from St. Thomas Aquinas in his theories of jurisprudence. Really interesting stuff. He says, can natural law be has it changed over time, and if it was true, would it be diminished? And he says, well, we can only add to things and take away from things, and that is a very interesting world. I wonder if these guys, Justice Park in 1836 and Lord Wensleydale, were thinking about these things. I don't know. Someone else named John Williams. All right. Hope you enjoyed this.